So
I think I welcome everybody to this webinar on the restriction of the freedom of contract, which we decided to have a webinar made between the two annual meetings. I think it's something useful and interesting to maintain contacts in the big IDI family. And so today we will have as program good faith first, and then the other unbalanced contracts. But in the introduction, I should say something about the collection of judicial cases. Can you show
yes.
what we have? So you will remember that we have been discussing a lot of court cases. We found also a lot of court cases for our past meeting of this year, of June of this year, and we have tried to collect them all, and we have collected them in different forms. One is the first one is a big collection of all cases all together. These cases are presented. You must have a big computer, a big screen to see them. But the idea, can you enlarge it a bit? Mm-hmm. I don't know. I think it's possible to have it a bit bigger. Anyway, because I am unable to see it. Yeah. So you have category, so distribution or franchising, and so then you have the country. B is Belgium, and then after, and then you have the parties, name of the parties, the court, document, date, and form of unbalance, and then the decision, and sometimes also the clauses, the relevant clauses. So I think if somebody wants to really understand the contents of all this is very important. Also because if you click on you get immediately the full text of the decision. So I think that's rather useful and important. Of course, we have. Can you go back? We have the same text. This is on PDF, so you get it like this, and you cannot change anything. You have only to look at it. But there is a version on Word which we have and which we can use and make better with the time, where you can, of course, mix up. You can decide that you want to organize them by country, by date, whatever you want to find something. Here you cannot, but that's normal, I think. But what is more important is that we intend to continue this, and when we find the new cases, and if somebody of you sends us new cases, we shall put them here. I think so. We will have a real important database in order to understand what are the risks of strange decisions or so that you don't foresee, and where you should be aware of them. That's, I think, all for this.
Can I add?
You can add something, and then you can present us. Right?
Of course. Okay, so yes, for those of you who were not at the last conference last year, just to mention that, yes, we had the plenary session dealing with this topic. So good faith, unbalanced contract, and all the ways of restricting the freedom of contract. Just to simplify, I can say. And so in that situation, we decided to, for the preparation of the conference, of course, and then also to keep it after, we decided to collect all the cases. And actually, we have also, with the collaboration of all these colleagues listed here, who were also participating to the conference, we collected all these cases, and my father also made a summary and all the descriptions and all what you can find you have seen here. So we have this list, the general list with all cases we have seen, which cover where there are 103 cases, just to give you an idea, and it covers 13 countries. So it is very complete, and you have the text of all the judgments. And then there is also the possibility to choose other lists which are limited to specific, so focus on specific issues. This is on encroachment, for example, and then there are others on other topics which were discussed during the conference last year.
Can I add one thing?
Of course.
I will now, I still need to check whether there are cases in these second kind of lists which are not in the general one. And so this means that I continue in making it better and better, the general list.
So that's why we thought it was good to present this work, not just to put it on the website that nobody knows, because actually it has been a huge work with all the efforts of everybody, putting everything together, exchanging views, and a very interesting work. So these documents are available if you go to the website in the home page or whatever page, in documents and tools here, and then you get to this page, and it is of course available for people who are members of IDI and have a subscription in IDI. Okay, so now we can go on with the first speech. I will take the prima l'apro, no? Okay.
Yes.
I will just 1 second that I share the screen for the. Okay. Okay.
Here we are.
So yes. So the first topic to be discussed is the good faith, as mean, and particularly, actually, the idea was in somehow to get some conclusions of all the discussions we had last year, and a comparison between civil law and common law. So Fabio Bortolotti and John Pratt will make this exchange of views between common and civil lawyer on this topic of good faith and protection of the parties against unbalanced agreements.
Okay, I will begin. If you can go to the next page. Yes, I first will try to explain how a civil lawyer sees the problem, the difference between civil law and common law. And thereafter, John will go more in detail on the signification on the of good faith in common law. So in civil law, the covenant of good faith is normally, of course, each country has his may have rather different solutions, but in general, it's a rule applicable generally to all contracts, and which is applied without particular limitations. The limitation can only be that there is not good faith, that it is not enough against good faith, but otherwise the case law will determine which clauses are in breach of good faith. in common law, the point of departure is very different because the basic principle, as I understand it, of course, is that good faith cannot prevail over express and non-ambiguous contract clauses. So if the parties really agreed on something and it is clear that there was no misunderstanding, then they may agree on something that is against good faith. It's their business. And so it's not for the courts to protect a party that willingly accepts a clause contrary to his interest. Then this is important as point of departure, but also the need to protect parties against abuses of good faith is so important that common law has developed a number of principles which limit and mitigate these general. And I pass the word to John, who will now go on and explain better, because it's not my business to explain common law, how it works in common law, where we will see that also common law is not the same in all the countries. So there are different aspects in America or in England or wherever. Okay, John, please.
Fabio, thank you very much. And can I extend my welcome to you all. 130 participants have registered for this webinar from over 30 jurisdictions. So there is an extremely well-informed and interesting audience, and I hope we can make this session as interactive as possible. I know that's challenging with webinars, but it will certainly be very helpful to get your input when we say something that you don't agree with, or you would put it differently. If I can just take a step back, the motivation for this focus on good faith was really something that Fabio said at the Bologna IDI conference earlier this year, which was he expressed concern that there seemed to be a misunderstanding amongst lawyers that when in the common law we use a concept of good faith, civil law lawyers believed it was very similar to the civil law concept of good faith. And as we'll see, that really isn't the case. So that was the first motivator, really just explaining the difference between common law and civil law. Secondly, we're seeing more and more common law jurisdictions belatedly, in some cases with difficulty, accepting a good faith obligation. So the tide is moving more and more in favor of some good faith obligations in common law jurisdictions. And then thirdly, we've noticed an increasing desire from the courts to protect weaker parties, both in civil law jurisdictions and in common law jurisdictions. For instance, in France, the Loi des Croisades, which was brought in on the 30th of March of this year, was seeking to reset the equilibrium, as they put it, in contracts between suppliers and distributors. And certainly in the UK, we've seen the courts increasingly, when they have to assess the reasonableness of a clause, which they do in post-termination non-compete covenants, and we'll see this in the case which we set out in a later slide. They protect the weaker party. So they protect parties which have to sign contracts in standard forms. So that was the motivator. The format for today is we'll very briefly explain why common law has a difficulty with good faith, because it's a puzzle to civil law lawyers. Very briefly, we'll then look at the differences between civil law and common law interpretations of good faith, but we'll also look at the differences between the various bigger, more relevant common law jurisdictions in the way that they approach good faith. We'll then look at a few practical steps in common law jurisdictions you can take in order to protect yourself from allegations of breach of good faith. And then Fabio has prepared a number of cases that will bring us down to earth, so that we'll stop talking in theory and at a high level and see how these principles apply in practice. There will be a question time at the end of the session, but as I said, if you have a burning desire to correct something that we've said, please do so. So, before we look at this slide, let me just explain to civil law lawyers why common law lawyers have a problem with good faith. First of all, the common law attaches very, very high importance to the freedom of contract. It says that people must be able to enter into contracts that they want to enter into, and it is not the role of the common law courts to alter those contracts to make them fairer. The second point is that the common law attaches very great importance to certainty. So they like contracts and the outcome of a litigation to be certain, which they consider to be much fairer than trying to alter contracts to make them fairer to one party. Thirdly, there was a strong feeling, certainly in English lawyers, that we didn't need the concept of good faith, because there were so many elements, less broad principles than good faith, but elements that could be used that would end up in a quite similar result to applying a general good faith obligation. And then lastly, the common law doesn't like general principles. It's not the way that it approaches the law. It approaches it from the other way. It approaches it from a decision of a particular case then being applied to other cases. So it's from the bottom up rather than from the up down to the bottom. So if we could have the next slide, and I think we have gone one back from that, I think. No. Where should we go? Yeah. Right. It ought to be no, you're going in the wrong way. There. Right. Thank you. So perhaps the easiest way of demonstrating the difference between the common law and the civil law is to look at Article 1104 of the French Civil Code, which says that all contracts have to be negotiated, entered into, and performed in good faith. And this is an obligation of public order. And in the next slide, we'll see what that means. And compare that, but not yet, but compare that to, if we could take it back here, thank you, to the US Uniform Commercial Code that's been around for more than 70 years. And what it says is every contract imposes an obligation of good faith in its performance or enforcement. In other words, the good faith obligation originates from the contract. And that's, as we will see in the next slide, completely different to the civil law concept. So the next slide. The civil law concept applies to negotiation, formation, and performance, number one. Number two, it's public policy, and so it overrides whatever is in a contract. A completely different starting point for the common law, because the approach to that the common law adopts is that the underlying aim of the good faith obligation is actually to give effect to the contract, to make what the parties have agreed work. So, in other words, the good faith obligation arises from the contract itself, not from an overriding general principle. Next slide, please. And we will see in the upcoming slides the big differences between the various jurisdictions. But I've set out here 3 elements that you regularly see in good faith obligations in common law. First of all, an obligation on the parties to be honest. Secondly, an obligation on the parties to adhere to what reasonable people would expect from contracting parties in terms of behavior and how they react. And thirdly, possibly keeping to the purpose of the contract, making sure that the purpose of the contract is actually performed. Now, we'll see that there's a question mark over that under English law, but those are the sort of 3, if you like, essential elements. Next, please. Right. So, as Fabio has pointed out, it is wrong to assume that common law good faith is like civil law good faith, and it's wrong to assume that the good faith obligations in all common law jurisdictions are applied in the same way. As we've seen with the US, they've become used to and comfortable with a good faith obligation for a very long time. And we've seen that it applies to all contracts. And Australia, another big common law jurisdiction, has adopted very much a US approach to this underlying principle applying to all contracts. Canada more recently has adopted a similar approach in a Supreme Court decision of Canada in 2014, where the Canadian Supreme Court unanimously accepted that there had to be an obligation of a general obligation of good faith in all contracts. But as we'll see in a subsequent slide, it's limited in some respects, but no, not if we stick with the obviously everybody's too keen to move me on. I'm talking too much. I'm getting the message to Sylvia. In England, a very recent decision in 2017 of a High Court judge in Yam saying it applied to a distribution agreement where the distributor was distributing Manchester United shirts and also distributing Manchester United perfumes and fragrances. Perhaps to nobody's surprise, the sale of perfumes and fragrances with Manchester United on them was not a great success. And so there was a falling out with the distributor. The distributor objected to Manchester United delivering their products and selling them more cheaply themselves. And this was the first case where a judge held that in what was called a relational contract, and we'll come to explain later on what a relational contract is, that there would be an implied duty of good faith. We've also listed the post office case, which again we will come on to. Now, generally, a good faith obligation will only be implied into a contract if it's necessary to make the contract work. And there's been a real fear amongst judges that this implying good faith obligations into relational contracts will lead to an avalanche of cases. And actually, we've seen that. We've seen pretty much in every contractual dispute a party arguing that there's a breach of good faith obligation. In the Republic of Ireland and within Europe, there are 2 common law jurisdictions, those in the UK and those in the Republic of Ireland. They have not adopted an obligation of good faith. In a recent case, the Court of Appeal in Ireland rejected a good faith obligation. I think actually what they did is rejected that the contract under review was relational. The case was Flynn v. Breccia. and they left the door open to introduce a good faith obligation. But currently, it appears that there is no good faith obligation in Ireland. So what I'd like to do with the next slide is look at the current English law position on good faith. As I've indicated, there's been a lot of disagreement amongst judges about the desirability of having a good faith obligation. In 2022, the English Court of Appeal handed down a judgment on good faith, repudiating the previous approaches of setting out a formula for what exactly good faith might mean. Because one of the problems we have in common law jurisdictions is that lawyers don't know what good faith means, how it will be applied. And in a previous case, the court had set out a formula for what good faith means. In this Court of Appeal case, the Court of Appeal said good faith means to act honestly, not to do something that's commercially unacceptable, but queried whether it also involved them involved the parties maintaining the common purpose of the contract. And the Court of Appeal wasn't convinced that that should be included in good faith, so wanted a much more restricted approach to good faith. I suspect good faith does include an obligation not to do something which makes the application of the contract more difficult. But that's me saying it. It certainly isn't an English judge saying it. Next slide, please. Next slide, thank you. Sorry, one back. Can you go back, Sylvia? Right. There, so if you stay there. Because of the uncertainty under English law about precisely what good faith means, there is a very simple approach to take. You could either put in a clause in your franchise agreement that says there are no good faith obligations. Neither party should need to comply with a good faith obligation. That would be unusual, and I think would not be the right way of resolving issues about uncertainty of good faith. But what you can do, and this is going to be picked up in some of the cases that Fabio has highlighted and we'll talk about, what you can do is set out what you believe the parties, what good faith obligations you believe the parties should comply with. And those obligations could be an obligation to respond to requests for consent reasonably and quickly. It may be an obligation to communicate effectively with the other party. So you can put very limited and, if you like, obvious obligations and set out that those are the only good faith obligations you accept. And the court will not, the English court anyway, will not imply additional or different good faith obligations. If you deal with good faith in the contract as a matter of English law, the courts won't interfere. Next slide. And this is going back to a point I made right at the beginning, and we'll very shortly be looking at the cases, which is much more interesting than what I'm saying. But I've set out 4 approaches that the English courts have taken to contracts in order to make them fairer. The list could be 10 or 12, but I've just picked 4. For instance, in the Interphoto case, when working on standard form contracts, much more relevant to franchising than to distribution agreements, you have to point out onerous and unusual clauses if you want them to be enforceable. There's a legislation was introduced, the Unfair Contract Terms Act in 1977, to prevent standard form contracts excluding a party's liability. There's a concept of derogation from grant, whereby the courts say you can't take away with one hand what you have given in the contract. And it originates from a case involving a Nigerian landlord who had 2 plots, one of which he sold to somebody who was going to build luxury flats, and the second plot he sold to somebody who was going to build an ammunition factory, and they were neighboring plots. And obviously the person who was going to build the luxury flats didn't see the funny side of it and objected to it, and the court said he shouldn't be allowed to do it. And then lastly, as I mentioned earlier, in relation to drain doctor, under English law, post-termination non-compete covenants will only be enforced if they are reasonable. And in the Court of Appeal decision in drain doctor, they emphasize that the court will always enforce what parties of equal bargaining power have agreed, but will not necessarily enforce clauses where there's a difference in the bargaining power. So those are the reasons why traditionally the English courts have been hostile. So Fabio, over to you. I've talked for far too long. With next slide.
Okay.
Next slide. Okay, now we go over to case law on good faith. Our idea was that in order to better understand the approach to good faith in common law, we will deal with examples of cases in various common law jurisdictions, and something also about civil law. But actually, since common law is much more complicated, and since there are more differences in common law, we will concentrate on common law cases. And as we will see, there are various doctrines which attenuate the general rule that the parties' agreement always prevails over unbalanced clauses. So I think that is important to see. If you can go to the next slide. So this is, I will begin with the general principle: good faith cannot prevail over explicit parties' agreement. We have this case of the Wisconsin Court of Appeals, so that's US, SuperValue versus DMart, and it says clearly Wisconsin law imposes an independent duty of good faith, and then whereas here a contracting party complains of acts of the other party which are specifically authorized in their agreements, we do not see how there can be any breach of the covenant of good faith. I think that is very, very clear position. You can go over to the next one, and then we can discuss. This is also very interesting. Häagen-Dazs, it's a case where Häagen-Dazs has extended its sales to another type of distribution, which was not a not nice new move to the existing distribution system. And so the distributors which had the system of sale which was used tried to contest this, and the court at the end decided that there is no breach of the implied covenant of good faith and fair dealing, since franchisor expressly reserved the right to distribute the ice cream not only through Häagen-Dazs shops, but also through any other distribution method which may from time to time be established. So this, I think, if you wait a moment, we go to the next in order to see the difference. Then I give.
And Fabio, if I may, just sort of the court, I think, put it very, very clearly in the Häagen-Dazs case. It said a party's exercise of its contractual rights cannot by itself be a breach of the duty of good faith. So if you have the right to do something in the contract, that will, and you enforce that right, that will not be a breach of the duty of good faith. Sorry.
But if we look at the next civil law cases, you see that here it's a bit the opposite what happens. Because here we have good faith prevails over unbalanced clauses, even when clearly agrees between the parties. And here we have this case of Milano GS Carrefour, here Carrefour has put has acquired a number of points of sale closer to the franchisee, and since the franchisees had no exclusivity, no express exclusivity, the franchisees terminate the contract, and the court says they are right. And the court ordered franchisee to reinstate the previous Carrefour. So here there is an existence of a breach of good faith, notwithstanding the absence of an exclusivity. And then if you go to the next one, the Isernia, here a franchisor undertakes not to appoint other franchisees in the territory, but sells controlled products through other channels at aggressive prices. Okay, the court decides that there is a breach of good faith and declares termination of the franchising agreement, notwithstanding that the franchisee had no exclusivity. This is probably a case where in common law also there would be probably a breach of good faith. I don't know, because there is not an express clause clearly stating this is admissible and this is good. So what do you think about this comparison, John?
Well, just to respond to your earlier point, yes, I agree with you that there would have been a similar decision as a matter of English law, because using the franchisor selling products through other channels at aggressive prices was precisely the case in Yam Seng, the first case. So I am puzzled, Fabio, by the civil law approach. So the parties agree amongst themselves that the franchisor has the right to appoint other franchisees or other distributors in the distributor or franchisee's territory. That's agreed in a contract, and yet the court will say, no, it doesn't matter what you've agreed, it's not fair. Is that a fair summary?
Yes, I think if the parties agree, I haven't such a case, because here they simply agreed on exclusivity. But I think that in this case, the courts will say, but they agreed something that is unfair and that is illogic. There are some cases where it is said it doesn't work within a system of franchising that you compete with your franchisees and so on and so on. So there is more space. It is not totally clear. I haven't found a case where clearly it is said even if the parties expressly agreed that the franchisor could appoint other people, he can do it if it's too bad for the franchisee. But I think that the tendency, the trend is that. Can we now go over to the limitations? This is more common law. I have tried to make a list. I don't know if I have been right, if I have interpreted rightly the situation. Any case, the basic principle, as we said, express clauses must prevail over the covenant of good faith. But there are derogations. First, unclear or ambiguous clauses, and we will see Scheck contra versus Burger King. Duty of honest performance, that is another category apparently. parties must perform their contractual duties honestly and reasonably and not capriciously or arbitrarily. Duty to exercise honestly contractual discretion. This is very, very important. We have two cases here, Canada and UK. Discretion must be exercised honestly and rationally. Then we have the relational contracts where you will explain clearly what the reason is, good faith in relation, but you have already said something. And then we have cases where it seems that we are very near to, very close to our civil law concept. Good faith covenant can prohibit conduct expressly authorized contractually, which is the case of El Polo Loco. Okay, so this is my general view. Do you have objections to this, or should we go over to the cases and look at the cases?
No, I completely agree. Let's look at the cases.
Okay, next case. This is interpretation of ambiguous clauses.
And I find, Fabio, this case
Yes.
very, very troublesome. It was a case brought by a very well-known and aggressive US franchisee lawyer, Robert Zarco. We've got to be slightly careful with this case because it was a case involving what's called summary judgment. So in other words, Burger King had applied to the court for saying, look, the franchisee has no prospect of success in bringing a claim against us, so find in our favor now. And in these cases, the judges and the courts don't go into a huge amount of detail. And the decision is, in my view, puzzling as an English lawyer, but there are US lawyers participating and they will correct me. But because what the franchise agreement says is that that there were no territorial rights granted to the franchisee. That's what it says at the top. And the court said, well, that's all very well. No territorial rights are granted. But that's not the same thing as saying you have the right to put another franchisee next door or in very close proximity. And so they looked very specifically at the wording of the contract and formed a conclusion that simply saying there are no territorial rights didn't entitle the franchisor to put another franchisee in. I think that's with all due respect, a surprising decision, but emphasizes that you need to be very careful with the wording that you use.
Yes, I agree. But I think that behind this, there is the idea that you should, if you can protect the franchisee against encroachment, if you can find a reason, you will find it because you have a certain sympathy for the idea that if he has a certain territory, he must also be protected. So that's a way of showing. And the next one also, I think, is something like this. No, this is very interesting. So this is the duty of honest performance. Is it something different from good faith obligation? That's, I think it's interesting. You can tell us something more about how this is categorized, this duty of honest performance.
Yes. Well, this is a decision of the Canadian Supreme Court. And it was a decision where the Canadian Supreme Court held unanimously that there was, as a matter of Canadian law, a duty of good faith, which they associated with honest performance. But even then, the court in my view, interestingly said, but this duty needs to be, and it's a duty that applies to all contracts. All Canadian contracts are subject to this duty, not as in the UK, just relational contracts. But then the court said, in applying this duty, you have to have regard to the legitimate contractual interests of the contracting parties. And you can only apply it in compliance with principles of common law, which attaches great weight to what the parties have agreed. So, if you like, although the Supreme Court of Canada absolutely accepted that there was this obligation of good faith, it sort of opened the door or to saying, well, you have to be careful in the situations in which you apply it, including where there are express contractual provisions. So I thought it was a very well thought through and interesting judgment from the Supreme Court.
Yes, I think that it gives you an idea about how complicated the system is. And so this appears very, very interesting to me. The idea that when you have to exercise your discretion as a party, then at this point, certainly you must do it in honest way. And so we have Hunters is a case that you have proposed. No, I don't remember.
It is a case that, yes, indeed. Sorry, Fabio, carry on.
So the idea that you must exercise discretion in a reasonable way. And so when you don't have a clear clause saying what is possible and what is not, but where a party has the possibility to decide certain obligations of the other party or to specify them, then this must be exercised in good faith. Did I understand well?
You did. The only thing I would add is that this principle of English common law, which is called the Braganza principle. So when a contract gives a contracting party complete discretion, so for instance, in a franchising contract scenario, you very often have a clause that says on renewal, the franchisee must enter into whatever the franchise agreement the franchisor is applying at the time. Where a party has complete discretion, it has to be exercised, as you put out, honestly and rationally. This principle preceded the introduction of good faith obligations in from the Yang Seng decision. So it's been around for some time.
Okay, go on. Relational contract, that is really for you, I think.
Right. Well,
I think it's very interesting because in relational contracts, you have the court has the possibility of directly applying good faith, no? A good faith obligation which goes against what the parties expressly agreed, or the parties did not specify.
So the post office case is the worst case of injustice in English history. The post offices entered into sub-postmaster agreements, which are very like franchise agreements. I was asked to review the agreement by the team defending the sub-postmasters who won, and it's very similar to a franchise agreement. And the judge in that case said that it's a relational contract and defined what a relational contract is. I won't set out how he defined it, but any long-term contract which requires the parties to work together would be treated as a relational contract. He set out in much more detail the requirements, but it's a useful case for working out what a relational contract is. And indeed, Fabio, he went further. He said, in these relational contracts, it isn't a matter of implying a duty of good faith, because as a matter of English law, you can only imply terms if they are so obvious everybody would agree, or they're necessary for the contract to work. He suggested that it was a matter of construction, so that if it's a relational contract, there will be good faith obligations. So he's gone further than other judges. So it's a useful case for re-emphasizing that relational contracts will be subject to a duty of good faith, for setting out what a relational contract is. And
what is really a relational contract? How can you define it? It's
well, I'll have to send you that part of his judgment where he set out the 8 elements of a relational contract. Unfortunately, I can't recite them to you now.
Of course you can. That's my fault. I should have put it, but I left this to you. I will look at it. I think anyhow, it's very interesting, this of relational contract. And it's for England, it's not for America and for the States for the moment. But then in the States, we have this case where El Pollo Loco, Pollo Loco. No, can go back. Questo è Pollo Loco. So a franchisor may be found to have breached the covenant of good faith and fair dealing implied in a franchise by placing a competing company restaurant in close proximity to a franchisee restaurant, even where the franchisee does not have an exclusive territory. I think here it looks as a direct application of the general principle of good faith, like we see it in civil law. I don't see a great difference. Of course, it says then where a contract confers to one party a discretionary power, you must exercise the discretion in good faith. In every contract, there is an implied covenant that neither party shall do anything which will have the effect of destroying or injuring the right of the other party to receive the fruits of the contract. It seems to me that we are very, very close to the civil law approach.
Fabio, I think it's an interesting case. I don't think it was decided, although our American colleagues will correct me, on the basis of good faith. The clause in the agreement made it clear that the franchisor expressly said that the franchisor could establish restaurants that may compete with the franchisee's restaurants. So there was absolutely clear wording. It went on to say, but if you can show that the restaurant that we've just put in has a negative impact on your commercial performance, you will receive compensation. So it struck me as a very fair clause. Certainly under English law would not be a breach of good faith, and I don't think it was treated as a breach of good faith by the Californian court. It was treated as a breach of the Californian unfair competition law. So my sense, Fabio, although I may not be right on this, is that it shouldn't be viewed as a good faith decision, but on the specific meaning of the Californian unfair competition law. But I may be wrong.
So then I will skip the last case, Violin Enterprises, because here too it is bad faith becomes clear. It's more or less the same, so I would go to the conclusions, and the conclusions are a white piece of paper. So we must insert the text. What are the conclusions? I say first, I think the conclusions are that there is a fight between a principle of protecting, in any case, the words, the sense of the contract agreed between the parties, pacta sunt servanda, and the more general need to protect weaker parties against unfairness. This is evolving in our law since the Code Napoleon, probably since since some centuries. In the common law countries, it is evolving in the more recently. And so you have this fight between these two ideas. One, if you agree on something, you have agreed, and you can't, if you really knew what you agreed, you can't say thereafter that it's not fair, because you agreed. And then the other possibility, yes, but you agreed because you didn't understand, or because you couldn't do otherwise, and so on. And so the trend is that you should not ask a party to agree on something that is not reasonable and that is not fair. So this is an evolution in the law, which is proceeding, but is proceeding not always and not in any country in the same way. And so it's very important for us practitioners to know what may happen under our contract when we are organizing franchising in other countries. And I was very much impressed by how interesting this evolution of common law is. It's up to you to conclude as a common lawyer.
It would be wholly unnecessary for me to add anything to your words of wisdom, Fabio. I think it was a very interesting and very well considered, if I may say so, conclusion. Thank you.
Thank you very much. I think that trying to understand each other from different provenience, from coming from different sides, is one of the most important things a good lawyer should do, because then we can understand the others and understand the position of the others, and that's very important. So thank you very, very much. You have really done a marvelous, given a marvelous contribution.
Perfect. So thank you very much. There are several questions already in the chat, but I think we can take them after the other panel. Maybe in the meantime, you and John could look at them so that maybe you could answer them during the Q&A session later if you want. Okay, so we will go on with our next panel of discussion. Federico, if you would like to share your screen with your with the slides. Ok, but in the meantime I will. Come vuoi stare qui? Vuoi andare lì? Okay, so yes, okay, so before that, yes, I will introduce, of course, this session. So in this session, we will deal with unbalanced contracts, particularly recent trends concerning unbalanced contracts. With reference particularly to the abuse of economic dependence and control of unbalanced clauses. We will start with the initial perspective from the perspective of General Counsel. Federico Rizzo will take this part, and he will introduce himself and speak about from this perspective. And then we will have a focus on Italian law that I will I will speak on that, and Frédéric Fournier will speak about French law. So I'll pass the floor to Federico so that you can start with your part. Thank you, Federico.
Thank you, Silvia, for the introduction. So I'm Federico Rizzo. I'm the general counsel of a footwear company, Diadora. We are a company selling in more than 60 jurisdictions, and we have like not a franchising, but a wholesale distribution system. Do you see my slides? Yes. No. Yes. Okay, just to give you a quick sight on what is the workload and day-by-day activity of an in-house counsel, we sign more than 300 agreements per year, and we manage, of course, various hundreds of agreements. Typically, in-house counsel not only deal with the theoretical cases and litigation, but manages the life of many agreements. So we need, it is vital for a general counsel, for in-house counsel, to adopt standardized approaches. We have standard agreements for each kind of contractual relationship, and those standards, based on the law and case law, also address all the risk inherent to a contractual relationship, often based on experiences and past cases. Moreover, we use very often English and US precedents that are, of course, very redundant and talkative and detailed about contractual provisions. So we very often start from a standard which is a structure as a tank, an armed tank, and through negotiations and taking and giving conditions, we end up, and the outcome is maybe a normal offside car. In Western legal system, we are used to, as Fabio was saying, to work on the basis of background of contractual autonomy. So the parties can agree anything which is worth protection. There is a mitigation of this principle that is social solidarity, and we know that employees, agents, franchisees, and collective interest like the competition and the balances of the market need to be protected. But apart from that, the stronger and the more aggressive, the better. The civil code in Italian law already gives an approach for unbalanced clauses in B2B relationship in general conditions of sale and contractual field form, so contrat d'adhésion. The technique of the legislators is precise and clear. So there is a closed list of cases of unbalanced clauses. For example, limited the liability of one of the parties, the possibility of the stronger party to withdraw, or imposing time limits for the other party to exercise its rights, and jurisdictional arbitration. It is a closed list, so we know where we're talking about. And the technique is a formal protection. So these clauses need to be approved expressed in writing. Now, this technique is not effective anymore, because any Italian agreement you will see will contain double signature, and so the weak party is not paying attention to those clauses anymore. More rarely, the law interferes with the merits of the clauses. For example, we are used, and this is also a provision containing in the Civil Code of 1942, that the judge, in case the penalty clause is excessive, can reduce it in relation to the interest of the party that imposed the penalty. So it is a control over the quantitative extension of the penalty. In common law, we know that there is a stronger approach. In principle, penalty clauses are invalid if they are the scope, the purpose is to deter breach rather than provide for genuine compensation. And in 2015, the Cavendish Square test, also common law, case law, open to the consideration of the balance between the interest and the penalty that protects the interest. Also, in 2000, a European directive deprived the parties of their freedom of contract in certain conditions for public policy reason to agree payment terms and interest rates. also in the performance of rebalancing the relationship between debtor and creditor. In 1998, the Italian legislator offering rules applying to subcontracting and manufacturing activities expressed the intention to bring balance in this peculiar business relationship where imbalance is endemic to the market structure. But under Article 9, where the legislator struck down the abuse of economic dependence, offer a principle that later on by case law was extended not only in subcontracting, but in any kind of distribution and supplier agreements where there is economic dependence. These case of first instance are all related to withdrawal by one party to the other. So the court in these cases considered that regardless of what the parties agreed in the agreement, withdrawal notice was not sufficient and not reasonable in relation to the contractual relationship. Of course, the involvement of some parties in these cases had an influence on the, disparity was a clear case in those cases, and also the imbalance between the contracts. This law of 1998 offers not, unlike the case of burdensome clause of the Civil Code, does not offer a closed list, but only examples. And defines what an abuse in business is. So a business finds itself in a position to bring about excessive imbalances in the rights and obligations of the commercial relationship. Examples are those: refusal to sell or refusal to buy, interruption of commercial relationship, and the clauses are clear. And the third case is the most dangerous because it does not speak about the clause, the content of the clause, but about the balance between the two parties. So the imposition of unjustifiably burdensome or discriminatory contract conditions. So in my opinion, the legislator here defines the term using the same term. So it says abuses in abusive relationship are forbidden. So it is a tautology, gives room to uncertainty and discretion of the judge. A similar approach was adopted by the Supreme Court in a case involving Renault and its dealers, where the judge said about public faith, the good faith, using the principle of good faith. So the judge, the Supreme Court said that the good faith is the expression of a general principle of social solidarity. And good faith imposed to each party to an agreement a duty to act in a way that preserves the interest of the other party. While as when I started, practicing law, my duty is to protect my client and my company from, negotiating with the other party, not to protect the other party. So, and the Supreme Court said that good faith is the tool for the judge suitable to control in a modifying or integrating function the contractual instruments used by the party in order to guarantee the right balance of opposing interests. And this is, of course, this decision of the Supreme Court was criticized a lot by professors and jurisprudents. And this case related to withdrawal again, ad nutum withdrawal. So we know in this uncertainty that in our company, we need to have procedures about withdrawal. And that very often what is agreed in the agreement is not sufficient. So, for example, we tend to give longer withdrawal notice to our counterparties, and also we send non-renewal letters even in case the agreement is simply expiring. I want to open a deep dive in France, because France is giving us, as usual, a lot of headache. And this principle of contractual balance and the control of the judge over the adequacy and reasonableness of notice period is inserted in the Code de Commerce that sanctions the sudden interruption of a business relationship and controls the sufficiency of withdrawal notice, and regardless of the business sector and regardless of the economic dependence. Another intrusion of the French legislator on freedom of contract is the Loi de la modernisation de l'économie, that interferes with the negotiating calendar of the parties. So the parties in a supply and distributionship B2B relationship are obliged to sign an annual agreement every year before March 1st, a convention unique that formalizes the result of the negotiation in order to avoid imbalances. This is clearly stated by the law. The convention unique is concluded for 1, 2, or 3 years and needs to have a minimum content, object, date of services, etc. And when it's concluded for a period of 2 or 3 years, the agreement must set out the terms according to which the agreed price is revised. So it is a strong interference with the freedom of contract, and there are heavy sanctions. So not petty sanctions. There was a recent case in the media that a purchasing group in building materials was fined for 6.34 million euro for a number of breaches. So this is, then Frédéric Fournier will go into deeper analysis of French legislation and case law later on. So you can imagine the organizational impact for the rest of the world. We have one agreement with some German or Spanish clients. With customers, we have agreements that date back on 10 years. With France, we have one single agreement for one single client, customer for each year. I want to go back to this clause. Very often, the outcome, the agreement signed is the outcome of a negotiation where the parties take and give, and not necessarily a clause which looks imbalanced has been exchanged for a clause relating to the same issue, but it is a negotiation relates to the overall content of the agreement, and negotiation is of course relevant. Now Silvia will go into deeper dive about a specific contract hypothesis, which is franchising, where Silvia has some interesting news coming from the competition authority.
Thank you very much. Okay, just 1 second that I will. One second that I take this slide. All right. Okay. Perfect. Thank you very much, Federico. So it was very interesting. So you have said many things about unbalanced clauses, which is a huge topic, and I will not speak about this general topic because it has been already dealt with by you and also by the previous session somehow. I will just focus on the abuse of economic dependence, and particularly considering the position, the approach followed by the Italian Competition Authority in some cases of franchising. You have already mentioned and explained the contents of this Article 9, this notion of abuse of economic dependence. There are, as you have already mentioned, there are several elements that the courts or the antitrust, the competition authority can consider in order to evaluate if there is a situation of economic dependence between two parties. One of these elements is the excessive imbalance of rights and obligations. But as I said, it is not the only one. Then if there is a situation of economic dependence, there must be an abuse. So one party taking advantage of this situation against damaging substantially the other one. What are the consequences? The consequences are that the pact is null and void, possible damages granted by the ordinary courts, and the competition authority can impose sanctions up to 10% of the turnover of the companies involved. So here, as I said, I will just focus on these three main cases, three main investigations opened by the Italian Competition Authority quite recently in the last years against three main franchisors. One is Benetton, McDonald's, and Original Marines. In all those cases have been closed before getting to a final decision and before getting to an evaluation, an actual evaluation of the actual application, if that notion was effectively applicable to the specific case or not, because the franchisors accepted, undertook to amend certain clauses of their contracts, of their model contracts. So in order to avoid a negative decision, they took this obligation to change the model contract in agreement with the competition authority, and the cases were closed there. So why these cases are important? They are important because, first of all, this is a public authority. So irrespective of the choice of forum clause, which can be the choice of forum clause or arbitration in the agreement, the competition authority can decide that wants to evaluate the balance of a substantial, and if there is a situation of abuse of economic dependence regarding specific contract. And the second aspect is that if franchisors take this decision to amend their contracts in order to avoid the negative decision of the competition authority, this is a modification which applies to all the present and future franchising contract of that franchisor. So I think it is quite important. So what could be the approach? First of all, criticizing this approach, and I have done it already several times. Many people would say, okay, again, Silvia will start complaining about this approach of the competition authority. Actually, I just want to say here that courts, because this is a claim, the abuse of economic dependence is a claim which is brought by almost every franchisee disputing against the franchisor before court, in national courts. And in almost all cases in franchising, with very few exceptions, these claims are rejected by the court. And particularly, there have been this year 2 cases, one against Benetton and one against McDonald's, which were rejected. But anyway, I will stop here with the criticism, and I would like to take another approach here. So to try to analyze, departing from the specific clauses which have been modified in these amended during these proceedings, and make an analysis in order to try to see what are the areas of concern to the competition authority, in order to better understand also the approach and the reasons and the concern. First of all, we have purchase and sale of goods. Of course, we all know that in franchising agreement there is a framework agreement, and then the sales of goods, of course, if the purpose is to sell the goods produced by the franchisor. So it is clear that actually, if there is a situation of economic dependence of the franchisee from the franchisor, based on a very unbalanced contract and many possible other circumstances which may create this unbalance, a typical and possible abuse may consist in the behavior of the franchisor, which could change or restrict some obligations of the franchisee. So changing, for example, the general terms and conditions, imposing more restrictive provisions against the franchisee. So that could be a typical case. In any case, I'm not saying that that was the case here, because the competition authority didn't get to analyze to that point. But in any case, those the provisions challenged by the competition authority here were the minimum purchase obligation, and now the automatic replenishment of the shop, and also it has been introduced a specific procedure for warning and reminders of late payments by the franchisee before allowing the franchisor to suspend supplies. Another area of concern regards the mandatory authorized suppliers. So this is a very interesting and critical issue in franchising, and actually next year, during the next annual conference next year in June 2024 conference, we will have a workshop specifically devoted to this topic. Anyway, here in the McDonald's case, the competition authority distinguishes between core products and ingredients, and for those it was clear that it was possible to impose suppliers to the franchisee, but for non-core products and ingredients it was introduced a procedure of approval by the franchisor, also of alternative suppliers suggested by the franchisee. And for ancillary services, almost a freedom of the franchisee to identify alternative suppliers, but of course with respecting certain conditions, quality conditions, etc. This is quite interesting. Then another interesting point regards the encroachment and non-compete obligation. Of course, this is also relevant for competition. In the McDonald's case, it was interesting that the competition authority didn't push for an exclusivity to be granted to the franchisee. So the franchisor was still entitled to open stores even close to the franchisee. However, it has been introduced an obligation to find agreed solutions in case of a negative impact on the franchisee's turnover. So this is quite interesting, I think, and it thinks of the case Polo Loco you were discussing before. In any case, and then the other clauses are the non-compete obligations. So also in the McDonald's case, the non-compete obligation during the contract were restricted to only specific type of restaurants, not all type of restaurants. And the post-contractual non-compete obligation was cancelled. This is quite disputable, but in any case, that was the decision. Finally, termination. Termination is, of course, an area, a delicate moment, of course, as we all know. And particularly, we all know that in franchise agreements, in most franchise agreements, there is no right for the franchisee to terminate the contract with notice. And here in the Benetton case, in particular, this right of the franchisee was introduced. So the right to terminate the contract for whatever reason with 6 months notice after the first contractual year. And in almost all cases, also the franchisor's obligation to buy back the equipment and furniture at the end of the relationship. So these are the main aspects evaluated in this proceeding. Conclusions. We can keep simply challenging the approach. I must say that Benetton for almost 2 years was trying to justify and to defend its contractual clauses, but in the end the competition authority clearly said that it was going to decide against Benetton, and that's when Benetton finally accepted to amend its model contract. But in any case, of course, even in the worst case of a negative decision, of course, there could have been a reverse decision in appeal. Anyway, I would like to also open another, how can I say, a different perspective. So this could also be an occasion for franchisors to reconsider the balance of certain clauses, because identifying the area of concern, of course, these are always situations and aspects which are quite critical in the franchise relationship. And I must say that as we all international franchise lawyers, sometimes we also see contracts which have some clauses which are very, very unbalanced. And so sometimes we also see that this is not beneficial in the end for the franchisor, because first of all, maybe the contract is not easy to be signed by the other party, but also because it gets to closure of shops, maybe in new markets. So maybe this could be an occasion for reconsider certain clauses, also thinking of maybe previous experiences with franchisees in similar situations, and also considering that, of course, new markets, new countries can have different characteristic, and maybe giving more space to the franchisee or the master franchisee could be beneficial, because he can maybe help also in adapting the system, the concept in the new market. So I will leave with this provocative suggestion, and thank you very much.
Okay, can I add one consideration? I think that this system used by our authority makes it impossible to have a review by the courts. So it's a way to avoid a review by the courts, because the parties accept in order not to have problems. And so sometimes even clauses which are not really so bad may be considered dangerous, and so this is a limit. The Commission, the European Commission, did the same in another case. I don't remember the name, and so I think that's a trend which sometimes might be dangerous.
Yeah.
You are waiting for.
So now Frederica is there. No. Okay. So I don't know if Frederica is not here.
I have to answer.
In the meantime, I think we can open, in any case, the Q&A session, so that in the meantime, there can be, maybe you could start by answering questions of the first question.
I have 3 written questions. Okay. So there are 2 questions by Dr. Rabbi Monzer, which unfortunately I can't answer, because one says which case of the Court of Appeal, but I don't know to what case he is referring, so I can't answer him. And the other said, even if it's not related to the public policy, but this sentence put there like this, I cannot give an answer. So more precise is the question by Tina Denso. She says, would it be fair to say that very generally, common law good faith obliges the parties to leave the contract in good faith, but civil law good faith goes rather to the interpretation of the contract? It's a bit obscure what she is asking, but I would say that it's not true, because in civil law, you are going to see if the clause is lawful or unlawful, if it is against or not against good faith. It is more in common law that you will go to the interpretation in order to overcome the principle that what the parties agreed it cannot be against good faith. So I think that is the problem. Last question, Ted Pierce, which is an American, I think. In civil law contracts, there appears to be three parties to an agreement: franchisor, franchisee, and the court. In civil law, it appears that one is writing a contract for the court. I cannot be in agreement. I think that in every jurisdiction, a party can object against the validity of a clause before the court. So there are not three parties. There are two parties, and always you can go to the courts. And everywhere, contracts must be written in a way that cannot be considered unlawful by the courts. So the limit of the control, possible control by the court is the same. The difference can be only that in certain cases, the courts will have a different view on the validity of a good faith clause of or a good faith. So I think
Maybe John would
John,
like to
would you? But John hasn't seen. Can I repeat?
No, he can see the chat. I think.
No, he cannot see it. Can you see it?
I did look at it before. Oh, and Frédéric's here, Sylvia.
Yeah, sure. So if you want to add something, or if you just close on these question, and then we will pass the floor to Frédéric.
Okay. In relation to the second question, if I've understood it correctly, I have some sympathy with what's being said, that the common law is not trying to change a contract, is not trying to alter a contract. It's simply trying to make sure that the contract that's been entered into works. And if that requires the parties to act in good faith towards each other, then that good faith obligation will be in the contract. If it doesn't require good faith, it won't be in the contract. So it's I think what was being referred to is the supremacy of the contract under common law. And there's one crazy final thought. In franchising, it is fundamental franchisors don't change their franchise agreements. I wonder whether the time has come for franchisors to negotiate their franchise agreements with franchisees. Everybody will think I'm mad for thinking that. I'm not saying it's right, but it's just a thought that occurs to me.
Okay, good. Thank you. So we will pass the floor now to Frédéric. You can share your screen so that you can have your slides.
Yes. Good afternoon, everybody.
Good.
I was sanctioned. I was in the audience, but not in the panel. Probably because I am the headache, as Federico said. So can you see my? Let me see. No, I'll try. Okay, here we are.
Perfect.
Can you see the document? Yeah. Okay. So for the French part, as Federico explained, we've got a bulk and a lot of decisions of provisions applicable in the civil code, but also in the commercial code. And everything was made with the idea that in France we have wholesalers and we have big distributors having a lot of power, purchase power. And then the suppliers were complaining about the fact that they never have the possibility to negotiate the agreements, the purchase agreement, the convention unique, as Federico explained. So this is the origin of this all, and the first law was voted in 2005 and then 2008, and there were a lot of reforms up to last month. So every year we have something new. Every year we have something evolving about these questions. The main provision applicable in France is in Article L 442 of the commercial code. So it begins with the possibility of a company when it is victim of an alleged brutal termination of what we call established commercial relations. So it means that there were several agreements, whatever they are, whatever the purpose of these agreements are, but there is subsequent relations, and in this case, there is a possibility for a party to obtain some indemnity if the notice period is not made in writing and not giving a sufficient period to the victim of the termination to reorganize. So we've got a lot of decisions about that. Just to be very quick on that, in France, the courts usually decide that you've got to give a 1 month notice period per year of relation, whatever the relation is, up to 18 months, because after 18 months, we consider that the notice period is sufficient. And if you look at the beginning of this article, you will see also a lot of provisions applicable to what we call restrictive competitive practices. The first of all is you want to obtain
Frédéric?
Ma mi sembra che si sia frizzato.
Okay, so we cannot hear Frédéric now. Maybe he will start now.
Of the French Civil Code in
Sorry, Frédéric, we couldn't.
and in this reform, there was a decision made by the parliament, but also the government, to include a new notion of significant imbalance in the contract. So we're talking about civil law. And this was not in the previous code. This provision is meant to cancel any provision of an agreement which would have not been negotiated and is significantly imbalanced. So this is a claim from the victim of the imbalance. And this is a litigation which can give the possibility to obtain the cancellation of the clause. But in civil law, you cannot discuss the imbalance of the purpose of the agreement or the adequacy of the price to the service, which is a good point. But there is also the French code, commercial code applying with these specific provisions, L442, 1.2, which gives the possibility to hold liable a company when there is a significant imbalance in the contract, whatever it is. It can be the legal conditions, it can be the sales conditions, it can be the price conditions, it can be the discount provisions, and so on. And the claim may be filed by the victim of the behavior of the other party or the Ministry of the Economy, because sometimes, for example, the suppliers are reluctant to file a claim against their purchaser, because these are usually big companies. When we talk about significant imbalance in civil law, but also in commercial, we always talk about a contract of adhesion, which means a lock, stock, and barrel agreement. You take it all, and you have no possibility to negotiate. And one of the major entry point when you want to file a claim about concerning significant imbalance is that you've been obliged to sign the agreement with no possibility to negotiate, or any possibility to negotiate where it's turned down by the other party. The sanctions in the French Commercial Code are quite significant, because there is first an administrative fine. So it means that there is a decision from the administration. You can have some remedies before the administrative court, but the administrative court will only review not the amount of the fine, but the legality of the penalty. So it's quite different from what we had 20 or 15 years ago. We had criminal fines, but not administrative fines, and there was a possibility to oppose the amount and also the legality. And the amount is quite important because you can have a penalty up to 5 million euros, or 3 times the amount of the benefits improperly received or obtained, or 5% of the sales made in France by the author of the practice. And there is always a publication. There is no cancellation of the clause if the victim is a company, for instance, but there is a possibility for the Ministry of the Economy to ask for a cancellation of the clause. So we have various possibility to have sanctions before this text. We discussed, Federico explained the Galec case. So Galec in France is the purchasing company of Leclerc. Leclerc is just like Carrefour, Auchan, and so on. And Leclerc has been the contracts of Leclerc has been reviewed by the French administration and the Ministry of the Economy. There were discussions about the consideration of some annual discounts claimed or required by Leclerc. And what is important here is that obviously the court decided that the clause should be and the discount should be cancelled, but also it explained that the court has always the possibility to have a judicial review of the price. So it means that if there is a service, the court, in this case, will have the possibility to say whether the price is proportionate or disproportionate in view or with regard to the service and the value of the service. So it is something which can seem weird for probably most of the audience, but and it was widely criticized in France, because we never know when we go to the court if ever the court will decide to review the price and say it should have been less or more. So this is something critical in France. The reasoning for significant imbalance or any abuse of dependence in the commercial code is always now a reasoning based on not on a clause-by-clause analysis, but on the analysis of the clause regarding the whole agreement. So it means that you need to prove that the clause is acceptable because bona fide by another clause or another point in the agreement. So the various decisions I listed here are just giving this reasoning, and now we have this clear position of the courts that there is no clause-by-clause reasoning. It was the position of the French administration to have a clause-by-clause reasoning, but this is not the case. And if I give some examples of what we have in the case law decisions, we have, for example, the possibility of a party to increase the products, the price of the products, but subject to the other party acceptation, when this other party has always the possibility to ask for the decrease of the price. So if the clause is not mutually or reciprocally provided and drafted, there is a possibility for the court to consider that this is imbalance. You cannot increase the prices, but you have to decrease the prices when it's possible. So this is the first example. We have also some decisions concerning logistics. And you probably know that every logistic company will use the same rate of 98.5%. This is a use all over the world. And there are some penalties if the delivery is not made on due time or is not compliant, and so on. But the courts in France considered that, and it was a case involving Auchan, it was not a balance provision. It was an unbalanced and significantly imbalanced provision, because the court considered that there were a lot of suppliers missing or not meeting their obligation, and there was no sanctions, or there were sanctions only when there was something like 70% rate for the level of service. So this clause was considered imbalance. We have also some decision concerning the termination, which is unilateral, without notice, without compensation. And the example here is that some distributors in their agreement decided that if the product is not good for the client and underperforming, there was a possibility for the distributor to return all the products to the supplier. Same thing about the return of unsold goods to the supplier. You need to have the consent of the supplier. If not, the clause is imbalance. Just the same about termination. If the termination clause is not reciprocal and it's a termination for convenience, you will have to give a sufficient notice period, but also it needs to be reciprocal. So each party will have the possibility to give this notice period. Other examples, you've got some decisions concerning the payment terms. The suppliers were required to pay within 30 days, and the distributor was paying within 60 days. It is not balanced, so the court decided to cancel the clause against the distributor's contracts. The same is decided about some practices of GALEC. GALEC is against, again, Leclerc, was used to make some pressure over the suppliers to obtain from them a waiver of any claim when there was something which was not legally acceptable. And in this case, even if in France we know that what we call transaction, so settlement agreement, is just like a decision from a court. In these cases, the court decided that there is a possibility for the judge to review the settlement agreement, even if it is just like a decision. If we go to, I will show you all other examples. We have decisions made concerning Expedia. First point is that Expedia was entering into agreements with UK law, UK jurisdictions, and forum, but the courts decided that we have a public order provision here concerning significant imbalance, and then it is considered as a loi de police, which means that there is no possibility for Expedia to claim that English law should apply or the UK courts should be competent. And the decision was made against Expedia to review all their contracts because they were asking to hotels to automatically give the best rate and the best promotional offers to Expedia and to keep the last available room for Expedia and not for other tour operator or any platforms. If we go to a significant imbalance, we have some decisions about the leasing agreements. And I'm just finishing. I've seen you text. Yeah, just finishing. You will find also some examples about franchise, and this is the last point I would like to explain. We've got several decisions concerning franchising, and all the decisions are made with the same mind and spirit. You need to have some negotiated agreements and the possibility to the franchisee to negotiate. So this was what I explained John earlier. And when you've got some clauses which are reciprocal or should be reciprocal, then the provision should be always reciprocal, or it can be cancelled by the court. You will find this in the slides, and clock is ticking, so I will leave the floor to Sylvia. Thanks a lot.
Okay.
Thank you very much. And sorry, but of course we are.
No, it's no problem. No problem.
Very good. Okay, so now I'm sorry that we do not have time for the discussion because there are just few minutes left, and we would like to anticipate to everybody the topic of the next conference, because it is we hope that all of you will join us for the next conference next year. So our annual conference next year will be in Prague. We will be in the Grandium Hotel, and we will have a fantastic gala dinner in a building called Obeknidum, which is marvelous. And it will be on 14 and 15 of June. You have received certainly already save the date. And for the content of the main session, I will try to explain what we are preparing.
So the main idea is drafting and managing contracts of sale within distribution networks, because we are specialized as IDI in distribution, but any distribution agreement gives problems of sale, because you are selling the products, and one of the problems that you have with your distributor and that he has with his customers is problems of sale, the goods that are not good, that have so there are lots of problems typically arising in this relationship. How can we approach it? Our first idea was we must teach all the people how the CSIG, the Vienna Convention on International Sales, works, because it's very important and it must be used wherever in place of domestic laws. Then we had some criticism, in particular from John Pratt, who rightly said that we as English, we have English law, and English law, he didn't say it, but I understood it, has been the international law of sales for many years. So actually, no, there is a tradition to make reference to English law, and I may understand that one doesn't want to enter in an unknown country if not necessary. So we have decided to change a bit the accent of these things and to concentrate more on cases and solutions which are the typical problems that arise in a sales contract with a distributor in particular, and make a relation with the CISG, and so to show how a certain problem would be solved under the CISG, but also under other national laws. And in particular, we want to consider English law, Swiss law, those legislations which are often used as neutral legal systems. What are the big, the main problems? We have here a lot of discussion panels. Which general conditions govern the contract of sale? This is a normal general problem that we have always. And how is the battle of forms accepted or treated in different legal environments, and in particular in the CISG? This is very interesting. How can the seller defend against claims for defect, non-conformity, invoked by the buyer without needing to discuss about their actual existence? This is a very important device. You don't want to enter into discussion, but you can invoke that the complaint is ineffective because it doesn't specify the nature of the defect. This can be a big defense in order not to enter into details. Invoking that the buyer did not notify the complaint within a reasonable time. And here, of course, the CISG is very important. Invoking that the complaint has been made after 2 years from delivery. Somebody doesn't know that under the Vienna Convention, this is, or provided shorter time limits in the general conditions. So this is an important aspect. Another important issue is, when is the buyer entitled to terminate the contract for non-compliance by the seller? And this is very important also for the seller. The seller must be sure that it's not easy for the buyer to say, no, you're a bit late, I don't want the goods you have already made, and so. And so we have here under the CISG the problem of the fundamental breach, and so on. This is also very interesting to see what case law says about this problem and how you can approach it. Then limiting the amount of seller's liability for damages. This is more general. It's not a CISG problem, but it's a very important problem because not all the companies understand. Then we have, I don't know exactly what I will say because we must speak with the experts, defective goods and remedies in the fashion industry. Okay. We want to put it into, but I have not yet. Then, of course, managing the relationship between framework distribution agreement and the contracts of sale. This is also very important, how you organize its relation. Then 7, comparing the possible solutions, domestic law of the parties, a well-established domestic law of a third country with respect to the CISG in some crucial issues, battle of forms, right of buyer to declare contract termination, defending about claims, etc. Then the pros and cons of the clause, which excludes the uniform phrase, sales law, and this would be the last. I want to insist that it is not thought as a propaganda for the CSIG, but at the same time, I am convinced that an international lawyer who is dealing with sales around the world must know what CSIG is and how he can use it to his advantage. I think that is something important. It doesn't mean that you must renounce to your own law, but in any case, I think it's important. And so I think that it must be very useful for our members. Yeah. And the idea, as you see, is to concentrate on practical issues which really are important in the management of relations with distributors. Thank you.
So, and the workshops there will be one workshop, as I mentioned before during my speech, on mandatory suppliers in franchise agreements and all the issues related to the contractual relation with the suppliers, and then the possible claims with franchisees, liabilities, etc. Another one on ESG in distribution and franchise networks. And the third one concerning the transfer of data in distribution network, and therefore all not particularly focusing on privacy issues that we have already dealt with in the past, but mostly on the value of the data and the transfer and the possible claims brought by the franchisee at the end of the relationship because they cannot access to the data, etc., or as a goodwill issue. So these are the main topics. We hope that all of you will come to Prague and participate to the conference. And we are very sorry that we didn't manage to have the discussion, because this was in any case a first attempt to have like a webinar, getting together somehow between one conference and the other one, so we can think of something maybe slightly different next year, so that we can allow you to participate more. But it was really good in any case to have this session, and thank you very much to all the speakers and to all of you, all the attendants. Yeah.
Yes, we are always very happy to have our family of IDI joining together, and I am very happy that in Prague we may have a marvelous dinner all together, because we are not only an association, we are something more. And I think that is, I believe very much in this, and I think that many of you also have the same idea.
Good. Yeah. Very good. So thank you very much to all of you. All the speakers, all the attendants, and see you in Prague. Okay. Bye-bye. Thank you.
Bye-bye.